Thanks for coming back. In this video, I will be discussing dual intent and what it means to have dual intent. Dual intent is essentially having two intentions, hence the word dual. That means two. Having two intentions, and in immigration, usually the dual intent are possibly contradictory. Usually when this happens is when you have or you want to file for permanent residency and also want to come in and visit Canada. So essentially this is dual intent. Your intent is permanent and it's temporary. Now, a lot of clients are confused about this, so I decided to do a video on this, hoping that it would clarify. It is totally legal to have dual intent. Now, the key here, and I'll give a very specific example, but the key here is to demonstrate that at the time of the application that you're currently submitting, your intent is X. So a good example would be, you have a permanent residence application in process, you filed this, you're currently waiting for a decision. But because processing times are so lengthy, you would like to come to Canada and visit temporarily. So let's, for example, use the permanent residency application under the federal skilled category. Currently, it's processing roughly about 12 months. Now, let's say you file this application and you would like to come and visit and see the culture of Canada, make sure it is suitable to your needs and so forth, and you just want to come and see the touristic attraction. When you submit the visitor visa application, it is important to disclose everything to the officer so that you're not charged with misrepresentation. Inform the officer that yes, you have filed permanent residence application, it's under the federal skilled category, you submitted on X date, you're waiting a decision and hope to get one by X date. So explain that to the officer. And then inform the officer that at this moment, when you're filing the temporary resident permit for, it's to visit Canada, and you're asking for X amount of months, you know that at this time, for the validity of the authorization to Canada, let's say the officer gives you 2 months, you understand that your stay is temporary, you understand that you're going to only visit, you're not going to be working in Canada or studying in Canada, you're simply going to go visit the touristic attractions, and at the end of your authorized stay, your intentions is obviously to exit the country and go back home. So as you can see, this is dual intent. You have filed PR, now you want temporary, but if the dual intent is explained clearly to the officer, then of course that's absolutely legal and you're able to have a successful visitor visa application, should the requirements of the visitor visa be met. So long as the officer is clear about your intentions, and so long as the officer is clear that you know that if the visitor visa is approved while the PR is in process or while you're going to file this application, then the dual intent is completely legal. So be upfront with the officer, disclose the past applications, your future applications, and your present application, and explain to the officer that you understand your legal rights and responsibilities while in Canada. I hope that clarifies dual intent. Until next time.